Namaste and welcome back to yet another immigration talk show with attorney Prashanti Reddy right here on Sakshi TV every Wednesday at 6 p.m. We just moved the time from 5:30 to 6 p.m. to cater our viewers we have a lot of requests from viewers in California and the Midwest. I hope you guys are okay. And just a recap from the last week's session, we talked about the entry ban, the proclamation by the president, and the rumors that we've had on the internet. And we spoke a little bit about the H-1B cap filings as well. And today we'd like to focus on the H-1B cap filing season. And we would also try to talk a little bit because there have been three tweets that people were banned from entering the US somewhere in the Europe airports. I've seen some tweets, I'm sure it's lingering on the internet and all the WhatsApp groups. Before we get there, I'd like to once again remind you this show is for informational purposes only. Sakshi TV or as a host myself, we will not be responsible for your actions. So please understand this is only for information and use any information at your own risk. I will try to take as many calls as possible. Would like to once again welcome Ms. Prashanti Reddy from the law offices of Prashanti Reddy. Welcome, Prashanti. How are you doing today?
Good, thanks, Dan. Thanks for having me. Looking forward to talking to everyone.
Wonderful. So let's before you have I have this mixed from the flyer that we did today. We have a lot of mixed questions here, topics, but then let's get started with the H-1B filings. But before we get there, I have one straightforward question about the H-4 EAD. Have you heard anything? Is this going to rescind?
Yes, it will rescind at some point if the present administration gets to do it while they're still in office. But what's happening is, as most people would know who are following this and who are interested in this, is that there was a lawsuit filed by Save Jobs. So there are two things going on simultaneously. One, there's a lawsuit by Save Jobs versus USCIS. And the other is USCIS itself has published a regulation for comment on removing of the H-4 EAD, but it hasn't happened as yet. The judge in the Save Jobs case gave USCIS until May 2020 to actually file the publication and finalize the publication, but I think that hasn't happened as yet, and maybe because of COVID and the courts being closed, so it's still on pause for now. Nothing further has been heard. We haven't heard anything in May or June.
So we were talking about the H-1B cap filings. So what's happening with the H-1B cap filings and why they need to send the applications before the June 30th? And what happens if there is a delayed filing? Is the 60-day grace period that they've given for the RFEs, is that applicable to the new H-1B cap subject filings?
Yes, absolutely. So as you know, this time with the H-1B filings, things were done a little differently. There was a pre-registration process, and for the people who got into the registration, we then had to file the H-1. So receipts were given.
Let's continue with what is the prominence of the June 30 deadline. Do we have a 60-day grace period?
Yes. So unfortunately, there's no 60-day grace period for the June 30th deadline. It's a hard deadline. And anyone who has been accepted, as I was saying, there's a whole new H-1B registration process this time. And the people who were accepted, there were about 35 to 40% of the applications were accepted in our office out of the applications filed. And what they've done is they've issued a receipt to show that they've been selected in the registration process, and then the next step is to file. So there is a deadline, which is not next week, but the coming week, June 30th is the deadline. And please remember that for our viewers, that if you've been selected under the registration process, and if you don't file, USCIS has said that there will be a penalty because you're, essentially using up a number. and you're not filing. So it's, frivolous registration, and I don't think they're going to tolerate that. So unless,
when you said,
go ahead.
When you said penalty, what is the frivolous filings and somebody's just trying to dump and take the registration numbers? Now, do we have any information about what kind of penalties? Is the penalty only the employer is subject to the penalty, or even the beneficiaries are going to get affected with these penalties, or regulatory changes or enforcements that can occur if they have not filed the petition or withdrawn the registration?
So basically, since H-1B is a employer-based petition, most probably the employers will be affected more so than the employees. And remember, for the employees, for the beneficiaries, they can file, even under the traditional cap, they can file more than one petition as long as it's with different employers. So that's an existing law that's possible, and that many, as you know, use that. They file under 3-4 different employers, especially students, because they're hoping to get into the cap. I don't blame them either, because the situation is so desperate that they're trying to increase their chance of getting into the lottery. So most probably it'll be employers who are affected rather than employees. And as to what the penalty is, they have not stated that. They have not told us. We have asked several times. Ayla has asked what the penalty will be, but could be some kind of a blacklisting, or it could be some further investigation. So we don't know exactly what it is, but definitely they would have to do something, because otherwise people would just frivolously take up a registration number with speculative employment, even though they don't have, a work for that particular employee. They might just say, okay, let's see, maybe we'll find work. If we don't find work, we won't file it.
Okay, so before we will continue with this topic, and we have a caller. Let's take the call, and somebody's got a question.
So this is
hello.
Yeah, so this is Gaurav.
Hi, Gaurav. How you doing? Where are you calling from?
Hi, I'm good. So I'm calling from Indiana State.
Okay, and what's your question?
So my question is, So thanks. My question is, due to family emergency, I'm on H-1B here, and due to family emergency, I may have to travel to India. So I have been hearing news about the H-1B travel ban that President Trump may impose. So, what is the recommendation here? Like, do we see the ban? Because my employer is okay to send me for 2 to 3 months. But do we have any idea for how long will this ban be? Like for 6 months or even beyond? Or
So, Gaurav, it's difficult to speculate as to what the period the ban will be for, but it will definitely be a ban it can't be forever. It most probably will not go beyond 6 months. That's what I've been hearing. So it could be any time from 30 days to 60, 90 to 180 days. And beyond that, as we know, elections are coming. So any new government that comes in will again take a look at, the past administration's executive order. So I think we don't have to worry about beyond 60 days, beyond 6 months. I don't think any court will agree to enforce an executive order which goes beyond 6 months. So you're looking at a maximum of 6 months. So if you have to work from outside the country remotely, be prepared to do that for 6 months. Hopefully, it won't affect you at all. Maybe only new H1s, not returning H1s. We don't know. So worst case scenario, I think you should be looking at the 6 months mark.
All right. Thank you. Now, before we continue with the session, I have another caller from Atlanta. Sridhar, you're on the air. Please ask your question.
Are you able to hear me now?
Yes.
Okay.
Yes, pretty good.
Good
Please
evening,
go ahead. Thank you.
So,
good evening.
Thank you. My wife and daughter, they're currently stuck in India. Now, my wife is on H4 and my daughter is an American citizen. And the speculation that's going on about the ban of H1, L1. So will that impact my wife? She's not on H1, she's on H4. And I have a follow-up question. Both my wife and daughter, they are Canadian permanent residents as well. So is it possible to fly to Toronto and from there enter US by road? Thank you, ma'am.
Yeah, before you,
Yes.
Prashanti, before you answer, I don't know if you've had a chance to read this. There was a tweet from somebody from Turkey who got into trouble. So we'll get there. If you can answer, you clearly understood what he was trying to explain, right?
Yes. So
Okay, please.
whether H4s will be affected or not, most probably it'll be H1s and not dependents. They're not looking to separate families. They're only, and since H4s are not taking up someone's job, unless it's a H4 EAD, that's a different story. But in general, since their perception is H4s are not taking up jobs, it might be targeted only towards H1 and that to arriving, hopefully only just arriving new H1s. Because remember, when there's an executive order, it has to be, the scope of the executive order has to be defined. They can't have a broad, if it's too broad, then it's likely the first day that the executive order is published, somebody will file a lawsuit, like they already have for the previous executive order. So if it's not well defined in scope and limited in scope with reference to duration and who is affected and who is not, it'll be struck down in court. So you can expect that it has to be narrowly defined if he wants it to be successful, if the present administration wants the executive order to be successful. So I would think that it would not affect dependents, but mainly affect H1s. And then with reference to your question about Canada, it makes no difference where they're coming from. The ban is not for Indian nationals or people coming from India. The ban is for anyone entering into the country, any arriving aliens on a H1 or, so they are not specifically targeting India, Canada, or any other country with reference to this particular topic with the next executive order.
All right, thank you, Gaurav. I hope she answered your question. Now, on these lines, what is that? Is it because the administration doesn't want people to come and take jobs, or they don't want people to carry the disease? What is the target? Is this something to do with COVID, or is just that there's a huge unemployment of 25-30 million people filing for unemployment benefits? Now, is this targeted at people that think that they're stealing jobs, or what is the target here? So based on what
So I think it's mainly political at this point of time. There might be some hardliners who have a misunderstanding of the job market and really think that immigrants, take away jobs. But I think my feeling is that it is really political in nature, and a certain base is being catered to that have certain opinions, and elections are coming close. So I think it's catering to a certain base. So I don't think it's because of health reasons, obviously, because, he has said as much in the executive order. The president has said as much. He has said it's for financial reasons, which are untrue because the statistics show otherwise.
All right. So, excuse me. So before we jump back into, I still have a lot of questions on the ban itself. I think most of the calls are related to the entry bans. But then let's go back into the H-1B cap filings. We cut off. So what happens if they have not filed, or there is a delay? They have beyond their control. They could not get to the office, or people are working from home. Now, what if they miss the deadline beyond the June 30, and if they can prove that this is beyond their control? Is there a way to continue those filings?
If I'm not mistaken, in the original, when they first made the announcement, they did say that there would be exceptions to accepting filings beyond June 30th, but I doubt if they'll really allow that. I mean, they make exceptions for everything, but they rarely allow that to go through. So if I was a company and I was filing, or I was the beneficiary and I had to get my case in, I wouldn't wait until after June 30th. I would file it before, unless I have completely no way of filing it because I don't have a job. Then what I would do is try to file it after June 30th. If you get a job, because you're not losing anything. At the most, they'll return it because there's no, because you are beyond the filing deadline. So as long as you don't mind losing a little money, there's no harm in trying. But I wouldn't do that if I possibly could avoid it, because we don't know what the scope of that is. We don't know what exceptions they'll make, and if they will make any exceptions for COVID, because they haven't said it. So I would just be very careful and only do it under the most extreme circumstances if I have no other option. So that's what I have to say about that, Dan.
And what about the cases where they can't file a change of status? And for example, there is a problem with CPTs. A candidate, a beneficiary who has accepted a CPT after their OPT, STEM OPT, now they have a CPT. There have been a lot of problems for a number of years. Now, what if they can't change the status and they have to go to the consulates? And what do you foresee when these consulates are going to open? And if somebody's here, if it's the first time applying for an H-1B visa, can they go to a consulate in Mexico or Canada, or do they have to go to the home country?
So yes, so you have to remember that when we file for a change of status application, the change of status application gets approved. They don't really have to go to a consulate, which is the good news. They can just start working as soon as the change of status application is approved. The only time they need to go to the consulate is when they need to travel. So when they need to travel is when they need to visit whatever, for business or for pleasure or to meet family. If they have to leave the country, then in order to come back, they definitely would need a visa to come in. And if the consulate in India is not open, yes, they can go to other consulates. Absolutely, that's a good question. They can go to Canada or Mexico or anywhere.
Okay, so we have another caller. Let's take the call and see if this is going to be about ban or it is going to be about the H-1B cap subject petition. Hello. Hello.
Hi.
Hi. How you doing? Your name and where you calling from?
Yeah, I'm calling from Georgia State. My name is Shrikant.
Hi, Shrikant.
I have one question. Yeah.
Sure, please go ahead. You can ask the attorney.
Yeah. Actually, this is about I-94 extension. I have a visa until actually October 2022 in my passport. That is my old passport. Actually, at the time of re-entry, I was given until this year end because of my passport expiration. Now I have a new passport with me. So what are the chances of extending my I-94? How could I do that without going to another country or to the border?
So if you have a visa, even if it's on an expired passport, it is still valid. You can attach it to your new passport and still use it. Now, filing for an extension of an I-94 is a different issue. You have to file, as you know, with USCIS. So there are two different issues. One is the visa and the other is the I-94.
Thing is, like,
Okay.
after I got my I-797, I traveled to India, got my visa stamp, and when I'm coming back, at the re-entry, they have given I-94 until this year end. So that is not an issue if I stay back until 2022 without any extensions.
Okay, so that's an important piece of information. So the I-94 that was given, whatever your last I-94 is, that you got last, that is the I-94 that you have to take into consideration. So the I-94 that was given at the port of entry is your valid I-94. I guess they gave it for a shorter duration, maybe because your passport was expiring, correct?
Yeah, correct. That is the reason they said at the time of re-entry.
Right, and that is a problem because we have tried to get that corrected by approaching CBP, but they say that passport expiry is a valid reason for them to give an I-94 for a lesser duration. So, I mean, what you could do is, because your H1 is for a longer duration, you can leave the country whenever you can, that is, if you're able to, that's one option, and come back. And when you come back, if your passport is now valid for a longer duration of time, you will get it for, your 3 years or whatever the duration of your H1 is. So that's one way of avoiding a H1B, filing of an H1B extension, because whenever you file an extension extension, as you know, USC, you have to deal with USCIS. And if the case gets denied, then it's an unnecessary hassle for you.
All right. You heard that. Thank you for that question. I think I think I should be joining you as a receptionist to answer calls today more than hosting the show. We have another caller, I think Praveen from North Carolina. Praveen, you're on the air. Please ask your question.
Hey, hi. Hi, good evening, ma'am. My name is Praveen. I'm from Cary, NC. My question to you is like, I am working for an employer, okay? So they were saying that I'm changing the client, but it's from different location. They are saying that you need not to file for amendment because it falls in the same MCA, like Metropolitan Statistical Area. So can you suggest me like what is the radius of the Metropolitan Statistical Area? So is it necessary for me to file an amendment?
So if you're within the same Metropolitan Statistical Area, you do not have to file an amendment. So what they're saying is correct. You can continue working for your new client. All the requirement is that you post the LCA at the new work location. That's the only requirement. You do not need to file. So usually MSA, if you go online and if you type in Metropolitan Statistical Area for your particular state, it will show you what is within your MSA. So make sure it is. Usually, if you're within the same county, for sure it will be the same MSA.
Yes, Praveen, go ahead.
It's not the same county, but it's not the same county. It's like 58 miles from my home, current address. Like that's what my worry. That's what like. Is it
so then
right to not file amendment?
Then what you need to do is check, verify it yourself. Go online, go to Google and type in Metropolitan Statistical Area, and then for your whichever state you're in, and then it will show you exactly.
And what about the commutable distance concept?
Yeah, so I would not go with the commutable distance concept because what is 50 miles? Is it commutable or not? Or is 15 miles commutable or not? Is 50 miles? So if you want to be completely safe, I would just go with the MSA requirement because that's a better requirement to follow. Sometimes within an MSA will encompass 2 counties sometimes. So just check and don't go with within commuting distance.
It doesn't matter with the distance, right? It can be 50 miles or it can be 60 miles.
Correct.
But
Yes. You could be in a huge state like New York where it could be like 100 miles. So it really doesn't matter what the distance is.
Okay. So, you heard that, Praveen. I think, Prashanti, why not they just, file an amendment, pull an LCA and just throw in an application? What is the hurdle in, filing an amendment? It's better safe than be sorry, right?
So filing an amendment is increasing liability because anytime you file anything with USCIS, you know that it's a hassle because if it gets denied, then your status is in jeopardy. So
yes, when you said the hassle, let's talk about the H-1B litigation. We'll get there. As I said, I'm your operator today. I have another caller, Shravan from Ohio. Shravan, you're on the air. Please ask your question.
Hi, Prashanti. How are you?
Hi, good. Thanks. How are you?
Yeah, I'm good. Actually, I do have a question for you. The thing is, I got my H-1B last year, and I got stamped in November 2019. First thing is, I got approval for 6 months, and I done with my stamping. But now in February, I got extension till 2022. But my I-94 is my previous one because I entered in my previous H-1B. Can I go to cross the border and renew my I-94? What is the process to do it, or else I don't know what to do.
So you said you applied for an extension again in February, correct?
Yes.
So your extension was approved until what date? The I-797 is until what date now?
2023 January.
So is there no I-94 at the bottom of your I-797? Did you not get an I-94?
No, I don't think so. I checked it actually.
But you should. It's likely that maybe there's some mistake there. You need to call your attorney or contact your employer. If you file for an extension, you should also get an extension of your I-94. Otherwise, what is the purpose of filing for an extension? You're asking for an extension of your status, so it should have been extended, for a period of 3 years or whatever the period is that you've asked for. So there's no reason for you to leave and come back if there is an I-94. Usually a courtesy copy, which maybe that's the confusion. A courtesy copy will not have the I-94 attached to the bottom. That's what the employer gets if they have an attorney separately. The attorney will get the I-797 with the I-94 attached. So it could be some confusion there, or it could be that they didn't approve your extension of stay for some reason. So you need to find out. You need to investigate further what happened.
Yes. Thank you, Praveen. Sorry, Shravan. I think this is looks like a more complicated personal matter. I'd like to request my callers out there, please keep your questions a little open, not very personal. But if you need legal advice, I think you should definitely be reaching out to Prashanti, our attorney on the session today. She can be reached at area code 212-354-1010, 354-1010, and her email is Prashanti with an H at readyesq.com, or you can visit their website at www.readyesq, as in Esquire, readyesq.com. So once again, we are just jumping off the topics, but I will take one more caller before we jump into the next session, and we'll take another 5 minutes. Callers, after this call, I would like to please call after 10 minutes. We are getting bombarded with calls today, but as I promised, we'll take as many calls as possible. We have Harini from North Carolina. Harini, you're on the air. Please ask your question.
Yeah. Hi, good evening, Prashanti. My question is regarding my OPT extension. Actually, in the month of December, I have received, I have applied for my extension in the month of September 2019, and I have received a letter from USCIS saying they have rejected my application. It is rejection, not the denial. They have rejected it because the check was not accepted by the financial institution. And my employer actually asked me to go back to India and get back my on H4 instead of being on and reapplying it because they might not consider my it might not be considered as a legal status because the process would take for 90 days. So once I'm back to USA, I'm back on H4 right now, and I checked with the university. They say still my SEVIS is active, and I can reapply for the OPT extension. So can you please help me? How do I have to do this, or if I'm really eligible to do this?
So you'll have to, since you're on a H4 now, what is important is what is your status now. If you're on a H4 now, then you have to again file for a change of status from H4 to F1. You can't automatically apply for OPT. You're not even on an F1 status. So, when you entered the country, you entered on a H4 status, right?
Right.
So you need to get a fresh I-20 and you need to apply first. I don't see how you can do that really, because you change status. Now to go back on an OPT, and how can you get onto an F1 without actually being on student
My F1
status?
is actually valid until 2022. I have my visa until 2022 F1. But yeah, as you said, I have entered the country in H4
Yeah, so then you have to leave, come back on an F1 status. And then if you're able to enter on an F1 status, then you can apply for an OPT, but still, there is a certain time period within which you have to apply for an OPT, and you've obviously crossed that time period. So that's an issue.
You have to resubmit the application. That's all.
Yes, correct. You have to, because you left and came back on a H4. The only thing to do is file an appeal. Or you can't even file an appeal because it was rejected. You have to resubmit the application.
Okay. Because I checked with if I have to get a new I-20, I have to be into a program, right? Now I am on H4, correct. So I cannot, I don't see any, way out to get I-20.
Yeah. Correct. You should, the fact that you left and came back and came on a H4 kind of blew it for you with reference to being able to resubmit.
Got it. Because I checked with almost like 5-6 attorneys at that point of time. They
All right,
said
thank
you
you.
cannot reapply, and they.
Yes, that's correct. Being on a H4, you can't again reapply now for an OPT because you have passed the time and you're no longer on F1. But we can discuss that further if you send me an email. There are some nuances to it that we can discuss.
Yes, thanks, Harini. Thanks for the call. Her email is Prashanthi, PRASHANTHI @reddyesq.com. Or you can also tweet us or follow us on Facebook. You can send us a message there at Sakshi TV, SAKSHI TV USA. That's our Twitter handle as well. Follow us for updates, and if you still need more information, if you are unable to reach the attorney, you can still send us a message, and we'll definitely make sure we will bombard her with phone calls and get the information that you need. So now we were just jumping off from, I think I would like to, for 2 minutes, I would like to focus on, once again, on the entry ban. I have this tweet. I'm sure, we were talking about this, but then why she was stopped, I'm sure the country Turkey is not a part of the any Muslim banned countries, but she was stopped at the airport. I think the CBP officers or the local immigration security, they told her that there is a ban in the US. You can't go to the US on a non-immigrant visa. Do you have any information at all?
So I think there was a misunderstanding there. I did look at the tweet that you sent me. So just to give some background to the viewers, there's this lady from Turkey who was coming into the country, but she came in through Europe. For some reason, her flight was routed through Europe. And because of that, and they didn't give her a reason why, apparently she was confused, because this happened the day after the executive order was passed, unfortunately. So she was confused as to why she was not being allowed back into the country, and then she had to go back to Turkey. But she was not able to come back, not because of the executive order on immigration, but because of Trump's decision on the COVID-19, when he said at that point he issued a different executive order which talked about people coming in from Europe. So there's a ban on that. And that's purely because of COVID reasons and health reasons. So that's why, because she flew through the Schengen area, through Europe, she was not able to come into the country. I think that was a reason, and it didn't have anything to do with her non-immigrant status or the fact that she was on a H1, or, she seemed to think that, but it didn't have anything to do with it.
Okay. So we don't have any specific data in terms of is this a rumor or the credible, incredible news that's been, going around on the groups and the internet. So what's upcoming today? They said it's going to be the 15th of June, 16th
Yes.
of June, and then Friday. So it's coming like a missile. We don't know when this is going to come and when it's going to hit. And people are really, really, really worried. So what is that we can tell them? Is it safe that they don't make any travel plans if they're especially stuck overseas, countries like India, and people who just got their visas last year, waiting to travel, the Octobers. So what is your advice here? What do you really foresee? What is going to happen? Let's talk about next 6 months.
So from what we're hearing, it seems like the executive order will affect, unless the White House drastically changes its mind, and that is possible also. So it's all speculation, but what we're hearing right now is that it will affect the guest worker program. The guest worker program is basically H's, L's, these are the guest worker, and the H1B ones, agricultural workers, etc. And it can only affect because of the scope of 212F, that's the Immigration and Nationality Act, under which any executive order on immigration can be based. 212F talks only about how the president can restrict or ban arriving aliens into the country if there is some national emergency. So first of all, he has to prove that there's a national emergency. And second, it has to be arriving aliens. So the guest worker program, then it will be only for arriving aliens, so arriving H1s, new. I'm thinking arriving should be new H1s. L1 should not be affected in the scope because L1s already have a job. And if he's saying the reason behind is all this is economic, then it has to be based on the job market. And as we all know, L1 are intra-company transferees, so they're simply being transferred from their business abroad to their business here. So that job is not open for anyone. So it's only open specifically for them.
Okay, so so you mean to say the dollar dream and the collar dream. So this is going to be on a temporary pause for the next 6 months or a year.
So the executive order, as I was stating before, has to have a limited scope with reference to duration as well. It could be 30 days, 60 days, 90 days, maximum 180 days. So yes, we are looking at a limited, that is the nature of an executive order. It cannot be for a permanent period of time. If he wants to do something that is more permanent, it has to be registration. Regulation, it has to be regulation.
All right, thank you. So before I still have a few questions on the, the H-1B cap subject filings. But then before we get there, I have another caller. Let's take the call. California just wakes up. Yogesh from LA. Yogesh, you're on the air. Please ask your question. Hello.
To visa.
Yogesh, can you hear me?
And yeah, I can hear you. Hello.
Yes, please go ahead.
Hello. Yeah.
Yes,
so,
please go ahead.
My visa got expired. I was on L2 visa, and I filed for visitor visa right now. And the third situation for me is my H1 got selected. So do I need to travel? My company got filed H1 visa for me. So do I need to go back out of US and need to come back, or can I stay continuously?
So it really depends on whether they filed a change of status for you or not. If they filed a change of status application, then you can remain in the country. You do not have to leave. If they filed a H1 for you for consular processing, a new H1, then you'll have to leave the country and get the visa in order to start working on a H1. So you have to find out from your attorney or your employer whether a change of status was filed or not.
Actually, they filed my H1, and I have not received the receipt notice for H1, but I have received the receipt for tourist visa. So right now I'm waiting for H1 status as I am visitor visa. So I can still continue with. I can still stay in US, but my question is regarding travel. So after H1 got approved, yeah.
So as I was just telling you, you have to reach out. I just answered your question. You have to reach out to your employer and find out if your H1 was filed as a change of status application or not. If it was filed as a change of status application, then you do not have to leave the country. If it was not filed as a change of status application, then you have to leave and then come back. For now, you can stay in the country because you are in status because you have applied for a V2.
Okay,
all right. Thank you for that call. Yes, please go ahead. Please go ahead.
Yeah, so actually, I have received notice for tourist visa, and after that, they filed H1B for me.
So they must have, again, you have to find out. You cannot presume that they filed a change of status from B2 to H1. You have to find out what was actually done. And if they did do a change of status, then you do not have to leave the country.
Okay, so I think it's a little complicated. You don't have data from your employer or the attorney. So I think it's a little difficult question without having data. As I said, the show is only for informational purposes. So you need to gather more information from your employer. If you have gathered information from your employer, you may still reach out to us or email prashanti@reddyesq.com if you need personal legal help, or tweet us or send us a message at Facebook at Sakshi TV USA. Before we continue the topic that got stranded, I have another caller from Dallas, Texas, Srinivas. Srinivas, you're on the air. Please ask your question.
Yeah, good evening. So, can you explain about the iVisa? iVisa, అంటే one of my friend iVisa లో ఉన్నారు. So, iVisa టైం అయిపోయింది అని చెప్తున్నారు.
Okay.
Yeah, iVisa, one of my friend iVisa అయిపోయిందని చెప్తున్నారు. సో iVisaకి ఎటువంటి రూల్స్ ఉన్నాయి? iVisaని ఎలాగా అయిపోయిన తర్వాత స్టే చేయడానికి ఎటువంటి అవకాశాలు ఉన్నాయి?
So the iVisa, it's basically journalist visa. And any non-immigrant visa that you have, any non-immigrant status, you have to file for an extension. And before the H1, before the iVisa expires, you have to file for an extension. మీరు ఒకవేళ extension file చేయకపోతే pretty much you're out of status. అట్లాంటప్పుడు your friend has to leave and get a new visa from the consulate and then come back in. I believe an iVisa is for 5 years. I haven't done one recently, but I believe it's for 5 years.
So an extension can be filed within the US. They don't have to go to the consulate if they've exhausted the 5 years.
I think beyond 5 years, you cannot. It's like a H1. You cannot file beyond 6 years.
There's a time limit.
And there is no other way of extending it. I think if you leave the country and stay out of the country for enough duration, then my information on this is sketchy, so I don't want to give him too much information. But, it's like any other non-immigrant visa.
Okay. So, 5 years on iVisa, H1 6 years, and then, is he eligible to file a green card if it's still, within the 180 days of, I heard that if people are out of status for 180 days and they apply for a green card, but looks like he's, speaking in Telugu, is an international. So any other opportunity for him to move out of the iVisa and into a safe harbor?
Yeah, he can file a change of status if he's eligible as a journalist. For example, he can file a H1 as a journalist.
Okay.
A journalist is a H1B specialty occupation. I've done many H1s for journalists. So he can file for a change of status to a journalist application, and then he gets a full 6 years on his H1, provided his employer, whether it be the newspaper or media, whatever kind of media, is willing to file the H1. So that's definitely possible.
Thank you. So let's jump back into, you've heard that, Srinivas, about the iVisa. I think you definitely need legal help. I think you should reach out.
And another option also, Dan, for the iVisa is the O visa.
O visa.
Because
what is
O
visa?
is for exceptional individuals in the arts, and journalism is definitely, one of the arts. So media people can file for an O visa also, and if he's interested, I can give him more information off the show.
Okay, I think the entire Sakshi team that is watching, they'll be happy to hear that the O visa is an option for them. Thank you. And now let's jump back into, okay, Srinivas, you heard that you have an option to jump from iVisa to O visa. Yeah, I think if you need help, you must reach out to the attorney. This sounds a little complicated than the general discussion we've been having today. Now, there has been a question there have been a bunch of questions, similar questions, in terms of when they filed the earlier until last year, when I'm talking about the H1B cap subject petitions, they would file on April 1st, and then you have 6 months, which starts on October 1st. But now if somebody filed on June 30, can they request a start date of, say, January 15, 6 months ahead, or it has to be October 1st?
That's a good question also, because with the COVID situation, most people cannot come by October 1st, even if they request it. And also another reason being is if you're filing for a change of status from an F to a H, and you want to make use of your entire OPT time, and you don't want to waste that time, so sometimes people file for beyond October. So yes, it's possible to file for a start date, as long as it's not more than 6 months from the time that you file the application. That's the only requirement. So if it's within the 6 months, because you can't file more than 6 months in advance. So if it's June, then it'll be July, August, September, October, November, December. So you can file for, like a December 30th start date or something like that. But remember, no matter what date you file the petition for, you can start whenever it's convenient for you. provided you're out of the country. If you're outside the country, you can, you go for a visa whenever it's convenient and you come in next year sometime. And that's what's going to be happening with most CAP cases.
No, but what happens if somebody's, in a change of status situation now? They have an approval change of status as of October 1st, let's say from H4 to H1, and how many days they have, or months or weeks, before they can officially get started with a payroll? Is it 30 days, 60 days, and is there a grace period for that, or they have to be jumped?
Yeah, this was only for people who are outside the country, but for people who are filing for a change of status, as soon as the H1 gets approved, they pretty much have to, then their status is considered to be H1. But of course, there is, as you said, a grace period of 30 days for change of status applications in order for them to get the social security number if they don't have it, for example, as you said, H4 to H1. It takes time to get an SSN number. So the employer can't put you on the payroll immediately. So that is acceptable. That wait is acceptable to get the SSN number.
So they will still maintain the status irrespective if they didn't get the SS number, or the employer wants them to wait for, say, 30 days or 60 days to, in terms of, in reality, mostly with the IT staffing consulting, where there are third-party placements and they want to, sometimes the client wants to wait, or they already have an H1, now they want to amend or move them into a different project. So that would apply.
So the only thing that can be done in that situation is that as soon as they get the SSN number, they should put them on payroll. And then after that, depending on the situation, as long as they're on the payroll, it's important that they be on the payroll. Otherwise, they're out of status. So as soon as the only excuse is that they don't have an SSN, but once they get it, they have to be on payroll, and then amendments can be filed, transfers can be filed, so on and so forth.
Looks like we have another caller. Our team, I'm not sure we have a caller. If you have a caller, can you patch in, please?
Hello.
Yes. Hi. What's your name and where you're calling from?
Hi, this is Kiran. I'm from California. My question to Prashanti Garu is, hi Prashanti.
Hi.
There is a news that is coming up saying there will be an executive order on the H1 thing. What will be the impact to existing H1 holders?
So as we discussed this at length last time as well as this time. So as I keep saying, there should be no impact for existing H1B holders, because an executive order is based on an Immigration and Nationality Act 212F, which gives the president the powers to restrict only arriving aliens from coming into the country, but doesn't give him the power to restrict non-immigrants or immigrants who are already here in the country. So it will have no effect on present H1B holders.
All right, wonderful. Thanks for that answer. I think we are now racing against time. I still have another one or two topics. This show today will be uploaded to YouTube. If you have missed the show, or if you want to just have a recap, we will be uploading it to Sakshi TV News. Just search on YouTube, Sakshi News. That's where we're going to be uploading these videos, and we will also slice these videos with each and every question and upload it to our USA Sakshi TV page at Sakshi TV USA. Please do follow us, and make sure, if you can share, please share, so others can get benefited. We've had pretty good questions today from our callers. Thank you. So Prashanti, let's jump into, before, I think we're running against time, but then what is the outcome of this H1B litigation, where the USCIS said, I think one of the trade organizations who've been actively fighting to get something out of the itinerary requirements, the Neufeld Memo 2010, the employer relationship memo. So what is the outcome? Is this some kind of a boon to their prayers or their lawsuits, or nothing has changed?
Oh no, it is a big development for H1Bs. It's a big blessing, because previously 60% of the cases are RFE'd, as a lot of you know, and out of that, half of them get denied, and most of the denials really are for right to control, in which they're basically saying that there is no relationship between the employer and the employee, the petitioner and the beneficiary, because the person is working at a third-party site. And that is the case in most of our IT staffing company situations. And then they were denying it on that basis for lack of documentation, etc. And they were asking for an arm and a leg, and even after giving them everything, they were still denying cases. So I think this is a big boon, because as per the lawsuit that was filed, and then consequently the settlement agreement, USCIS has agreed not to ask for the employer-employee relationship. So they will no longer ask for these onerous contracts between all the parties, the POs. And then in addition to that, the other thing that has came about with this settlement agreement and the lawsuit is that previously USCIS was giving short-term approval. So if the purchase order was for 3 months, they were giving only 3-month approvals. I've had an approval for a day, which was only valid for a day. So things like that were happening, ridiculous things like that. So now they've said that they will not approve H-1Bs for a shorter duration of time. They will approve it for the entire 3 years. And even if they do approve it for a shorter duration, they have to have a concrete reason as to why they're doing that. So that's another good thing that came out of the court case. And if they don't do that, we can always go to court and litigate. In these cases, they're becoming so easy to win and so inexpensive that most probably it would be cheaper to litigate than to actually, refile with USCIS. So those are the two important things. And the third is, of course, the itinerary requirement, like you were saying, which again falls back to the same thing, that you don't have to show employment for every single day that you want the beneficiary to work. If you're filing the H1 for 3 years, it's not necessary that you have to account for every single day out of those 3 years and show, purchase orders for 3 years. It's enough to show that you have potential work that's not speculative at the time that you're filing. So even if you have a purchase order, say for 1 month, that should be sufficient for you to file and get an approval on a H1B. So now done. The only problem is that this is good only until new H1B regulations come into place.
No, that's where I'm coming at. Yeah. Now, if everyone starts filing a case, so let's say if there are 1,000 denials in a year, 1,000 RFEs, or I'm sure more, with 500,000 people on H1B visas. now they have amendments, extensions being filed. If 30% get in trouble, we're talking about 30,000-40,000 people, companies rather, filing lawsuits. So this is going to get chaotic, and then we don't know what's going to happen in the future. So, or they might just say that these can't be dealt in the court of law. You still have to go to the appellate board and start appealing. Do you think that's going to happen?
No, I think what's going to happen is they realize now that they can't. USCIS realizes, and the White House realizes that they can't play with the law and just interpret the law any way that they want to. And USCIS has been getting away with this because of lack of litigation. You would be surprised people are not willing to litigate, actually, because they think it's a big deal and it's very expensive. So luckily for us, that mindset has changed a little bit. So, but now they realize that they can no longer deny cases on frivolous grounds. So now what they're going to do is they're going to try and file, maybe publish new regulation, because there is regulation pending. So that is part of the White House's agenda, is to publish new regulation on right to control.
All right, Prashanti, I think we already ran out of time. I've had a little trouble here listening to my PCR team, but thank you once again, Prashanti. Let's say goodbye for tonight, and we will definitely try to come back on Wednesday at 6 p.m. tomorrow. Signing off, this is Dan Nandan with Attorney Prashanti Reddy.
Thank you. Good night.
Thank you.